In the present module, I am going to make you to understand what is cloud computing and what are the legal issues it raises by the cloud computing after deploying it in business entities, government sectors, or any other organization. The objective of these modules are to explain what is cloud computing and its limitations, to identify few legal issues raised by it, and to explain about few international regulatory framework to address these legal issues. And it includes the summary. And I have outlined this PPT presentation in 5 parts. Part 1 includes the introduction and background to the subject, and Part 2 explains what is cloud computing, and Part 3 explains the legal issues, Part 4 about the regulatory framework, and Part 5 is the summary to this subject. And before going to the subject directly, what is to understand what is cloud computing, it is very essential to understand what is information technology is, because the cloud computing is not a new innovative technology. It is just a part of development of information technology, and the legal issues raised by it is part of the cyberspace. So let's understand what is information technology is. Information technology is defined as the use of computers and software to manage the information. The information technology company is responsible for storing the information, protecting the information, processing the information, transmitting the information, later retrieving the information if needed. And this definition is taken just because the information according to this module is considered as a data under cloud computing. And the adoption of information technology is very fast, and information technology is becoming part and parcel of our life today. So if we observe this slide, we can understand how fast we are in adopting the information technology. The telephone took 70 years to reach 50% of the household. Radio took 28 years. According to the current trends of new tool of social media, Twitter took 780 days to reach 10 million users. Facebook took 852 days, and Google Plus took 16 days. Finally, Internet took 10 years to become a basic and essential part of our life. So the new technology is outplacing the old technology, and in near future it may take some days or weeks to adopt the new technology. And according to this slide, if we observe the status of cloud computing, it is a fifth generation of cloud computing, fifth generation of computing after the mainframe, client server, and internet and mobile technology. And according to markets and markets.com, cloud computing is growing very fast. And it started with $37.8 million in the year of 2010, and $121.1 million it is going to reach in the year of 2015. And cloud computing is becoming a very important technology in today's business life or for the government, just because it is very cost effective. And the government or business organizations, startup companies can rent the IT services, and the IT services are available for 24/7, and it is scalable in nature, and it is very fast. It delivers the service instantly, and it is flexible, highly secured, and it is very easy to implement. And the cloud computing service can be tailor made according to the need of the business. And after the recession, entire world was looking for some technology which should be cost effective, and the cloud computing became one of the major trend. And this was the main reason for the fast adoption of the cloud computing. So now let us understand what is cloud computing is. According to NIST, National Institute of Standard Technology, US, the cloud computing refers to a remote computing where the different services such as application, software, network, server, storage, or infrastructure delivered to the users through the internet. It is just like a electricity consumption. Users have to pay according to the consumption of the computational power. So, cloud computing is just like renting the IT services according to our consumption, according to our need. We can use the computer services which through the internet. So it is a remote computing, and without internet, it is very difficult to access the cloud computing services. But if you have the internet services, it is very easy to deploy the cloud computing services. So cloud computing services is divided into three service module, that is infrastructure as a service, platform as a service, and software as a service. In infrastructure as a service, the cloud customer can take entire infrastructure, information technology infrastructure as as a rent, for their use. And few examples are like Microsoft Azure or OpenStack or Amazon AWS. And in platform as a service, the customer can go for few platform, as a can take few platform as a service to use or manage their applications, and design or develop some applications over that platform. And in software as a service, the consumer can take few software application for their service, and that includes Gmail or Yahoo Mail, like Google is providing or Yahoo is providing. We can create our email IDs, and we can access our information through the email. We can exchange the emails. This is the example for the software as a service. And cloud computing is divided into four deployment model: private cloud, public cloud, community cloud, and hybrid cloud. Private cloud is designed to few specific customers and dedicated to few specific customers, and public cloud is accessible to the general public, like we open our Gmail account, or we browse through Google Chrome. And community cloud is like organization which have their specific needs, like education institute needs some specific application, and some manufacturing company needs some specific applications. Group of institutions or organization which has same some needs, similarities, they can share this community cloud. And hybrid cloud can be any combination of public cloud or private cloud or community cloud. Any combination is called as a hybrid cloud. Uh, but if we observe the service model of the cloud computing, or a deployment model of the cloud computing, we will be accessing the services uh, through the internet, and the cloud service provider will provide some password to us, and our administrator from the organization can access the cloud services and store the data in the cloud, which is managed by the third party. And the entire information of our organization or business entity will be stored somewhere remotely. This raises the legal issues exactly. The cloud is not transparent, and the customer's data, which is stored in the cloud, is not visible to the customers, and customer won't be having control over the data which is stored in the cloud. And it can be hacked by the third party, or it can be accessed by the cloud service provider. And the data which is located in remote location can be accessed by the cyber criminals. So But these are the legal issues the cloud computing service rises. So, specifically, let us see what are the legal issues raised by the cloud computing now. So, cloud computing raises the data protection issues, jurisdiction or conflict of law between the countries, and it raises the issues of contract and liabilities between the customers and the cloud service providers, and the accessibility or possibility of the data accessed by the third party, which is not transparent in the contract. And the cloud computing raises few challenges to the digital investigation for the government authorities. Why the data protection is a big issue in cloud computing? Because the data processing and storage take place somewhere in the remote servers and the data centers in the cloud, and cloud customer won't be having any knowledge about where exactly his data is residing at present. The data can be accessed by the third party service providers. Sometimes the cloud provider will take the software of the one manufacturer and the hardware of the other manufacturer, and the cloud provider will bring all the software, servers, and hardware applications together, which belongs to other people or other party, and the customer won't be having knowledge about that, and he will be accessing the cloud computing services as a single. He considers cloud provider as a single entity. So but the third party involvement, idea of third party involvement in the cloud service provider is not mentioned in the contract. So this raises the data security issues in the cloud computing. uh, so why this becomes a major issue? Just because the data can reside somewhere in other jurisdiction also. For example, from this slide we can understand the client will be accessing the cloud service through the internet, and the data centers may be placed somewhere around the world. The data centers of the cloud service provider may be in US or somewhere in France or somewhere in Japan, and the client the client may be belong to India, and in the contract they never mention about where exactly the servers or data centers are located and where exactly they are going to store the customer's data. So, and the contract or SLA, service level agreements are called as SLA under cloud computing, and the contracts are very much silent about these issues. They never mention how the privacy policies are regarding and protecting the customer's data, and the civil or criminal liabilities are not mentioned properly in case of breach of these data. So the contracts are standards in the market. The small and medium scale industries cannot negotiate about these issues in the contract. Only the big players can negotiate it, and the cloud provider will be having more power over the contract than the customer. And while providing the service, they never show those flexibilities in negotiating the contracts. The terms and conditions of the contracts are very much in standard. So it is impossible to negotiate or negotiate the contract according to the need of the business. So there is a need to research on this topic. How to negotiate the terms and condition of the contract. The Queen Mary University is researching on this contract and its liabilities, and they came up with a few contracts of the company, like grow grid or rack space elastic codes, and just they studied a few contract of those companies, and the contracts are much silent about their responsibilities in protecting the data. If we observe this slide, you can understand easily how they have mentioned their terms and conditions to protect the data. And in cloud computing, there is a possibility of third party access to the data, customers' data. The entire, sometimes the entire cloud can be hacked by the hackers, or sometimes the data can be accessed by the outsider. Sometimes it can be accessed by the insider, and sometimes without the knowledge of the customer, the government authorities can access the data, like which happened in through National Security Agency PRISM scandal recently in USA. The NSA was accessing entire different countries' data, because the USA was having major cloud providing or internet providing organization in its jurisdiction. It was accessing the data of various countries and foreign citizens in the name of protect the country from the terrorist after 2011. So these are the legal issues rises by the cloud computing, and the final one is digital investigation. And if some legal authorities or government authorities want to access some data of some customers for the investigation, it is very difficult to access the data from the server which is located in different jurisdiction, or technically it is very difficult to access the data of a particular customer because of the technical thing, because the same server can have the data of many customers, and there is a possibility of deletion of data, or exchange of data, or extraction of data of other customers. So e-discovery or digital investigation is very difficult in cloud uh, environment. And if we observe few regulatory framework in the international level, for example, OECD guidelines, or Council of European Convention of 108, or APEC privacy principles. Entire world, around the world, many countries are having the data protection laws, and those data protection laws can be combination of these international regulatory framework. And each and every nation will be having their own data protection framework, like European Union data protection directives, and United Nations will be having its own data protection laws for law, and India will be having its own data protection law. But data protection laws can be dedicated, or data protection law is combination of privacy laws. So it leads to misunderstand the concept, to understand how to protect the data in the cloud computing environment. The Organization of Economic Cooperation and Development, OECD, is the first international guidelines on privacy protection. The OECD guidelines on the protection of privacy and transborder flow of personal data were framed in Paris in the year of 1980, which apply to 30 OECD countries. It includes UK, USA, and some European countries. The basic principle of OECD guidelines are like collection limitation principles, data quality principles, use of limitation principles, security safeguard principles, openness principles, individual principles, participation principle, and accountability principle. OECD guidelines are influenced on national legislations in many countries. The EU data protection directives has adopted the first 5 principles of data protection of OECD guidelines. And The OECD guidelines are old guidelines which are drafted many years back when IT was not developed properly, our internet was not developed properly. Mm, but OECD guidelines gives the harmonization kind of thinking to the nations uh, to protect the data, and it regulates the trans-border data flow. But specifically, it is applicable for the personal data. And this EPIC privacy principle is implemented in the year of 2014, and it follows OECD guidelines, but it is based on accountability principles. And the companies can transfer the data across the border under cross-border privacy rules of EPIC privacy policy, but the countries are not bound by the ABEC privacy principles. And country-wise, if we see, EU laws are best data protection laws in the world. That is 95/45 VC, and EU directives are applicable to it member states like 27 European Union nations. And EU directive considers data protection, personal data protection, as a fundamental right, and it defines who is data controller and data processor, and it has ruled that right to be forgotten is right of an individual, and according to that, the cloud provider should on the base of demand from the customers or notice from the customer, they should remove the content if it is objectionable, and if it is uh, violating some right of an individual, the cloud service provider should remove those content from the cloud. And EU data protection laws are updated, and it protects customers' data in the cloud service. And when it comes to United States data protection laws are sectoral in approach, and USA never considers the data protection or protection of personal data as a fundamental right, but it protects the data as a customer rights. And the cloud provider, being a commercial entity, company, it should protect the data according to the contractual clauses and terms and condition of clauses with the customers. And like US has a sectoral approach, like financial institute will be having separate laws, and healthcare data will be having separate laws. Children's before 14 age will be having separate laws. For foreign customers, they will be having a separate laws. So it is very difficult to apply these laws, set of laws, in the cloud environment, because each and every kind of data in the cloud will be applicable under some laws, and it is not uniform in nature. So US laws is a bit difficult to bit difficult to apply in the cloud environment. When matter comes to India, India is largest member in SARC, but it is not a member of OECD or APEC, private APEC. In India, if we observe, the Information Technology Act 2000 is a main enactment, and it is amended according to the development of technology. An incident happened in India. It has amended in the year of 2008, and once again in the year of 2011, which is called as Information Technology Reasonable Security Practice in Procedures and Sensitive Personal Information, called as IT Privacy Rules 2011. The data is defined under section 2, clause W of the IT Act 2000, and according to IT Act, the cloud provider will be considered as an intermediary service provider. So he is liable for the customer's data, And under the IT Privacy Rule 2011, Section 43 is says about compensation for failure to protect the data, and section 72 is punishment for disclosure of the information in breach of lawful contract. And according to the privacy rule, the corporate entities or body of corporate which collects, process, and storing the personal data, that includes the sensitive personal information, is responsible for the data protection. And any entities which collects the data on behalf of any body of corporate is responsible for protecting the personal data. And there is a proper limitation period, and the company should display the privacy policies in their website in time, and according to the customer need they should alter and protect the data and save the data. And in case if they need to transfer the data to some other entity, they should inform to the customer in time, and they should take the permission of the customers to transfer the data to other entities. And according to these privacy rules, a cloud provider can be treated as a body of corporate, and he is liable for the protect the customers data. And any other entities which collects the data on behalf of the cloud provider is liable to protect the customers data. But the Indian laws are absent in defining the protecting the foreign citizens data in India, and protecting Indian citizens data in foreign jurisdiction. India being a IT service provider will be is having n number of foreign citizens data in India, but the Indian laws are silent about this. And cloud computing is in global in nature, and the Indian citizens data may travel in different jurisdiction. For example, we are using the Google service, we are using Yahoo service, and our and many government entities still using the foreign cloud services, and many state government are coming up with the cloud services. And Indian government is now coming up with the digital India concept and smart city concept, and adopting the cloud computing in the government sector and private sector. And the e-governance projectors are adopting the cloud technologies to deliver the fast and effective service to its citizens. For India, it is very important to have proper data protection law for the technology. And the technology, if we observe US laws, it is sectoral in approach, and if we observe the EU law, it is having very strong dedicated data protection laws, well defined data protection laws. And recently India is coming up no, came up with the 2006 data protection bill, but as still in the parliament it failed already. And recently they have submitted Shah committee report regarding the data protection and privacy policies, and the government had to implement it. So the cloud computing or any other future technology needs well defined and technology neutral laws. The cloud computing is very useful in nature, and it has benefits. At the same time, it has the legal implication or technical challenges. But we are adopting the technology, whether it is cloud computing or any other technology in future technology, and the entire world is depending on the technology now. Without tablet or cell phone or mobile cell phone, even we cannot think about moving out from our home daily for banking or purchasing, for entertainment, we are depending much on information technology. So it is when technology is becoming integral part of our life, it is very important to come up with proper laws which should not be dedicated to particular technology. So instead of innovation in the technology, we need some innovation in law, because today data is becoming a business. Data analytics is becoming a business. On the base of data analytics, they are constructing the business. So this is very crucial time to understand the nature of data, understand the nature of technology, understand the protection of human right, and protection of privacy of person, and development of the commercial strategy, development of the economic strategy. So it is very important to think about law, technology, and the development. So for that we need some international cooperation. International cooperation plays a very important role when we draft our the law for the technology. So technology neutral laws are very much important. International cooperation is very much important than innovation in the technology. Innovation in the law is very important. Data is becoming business today, so protection of the data in the cloud environment, or any other future technological environment is very much important. Thank you.